Hi, my name is Mark J. Davis. I'm a retired attorney. I've practiced music and entertainment law since about 1978. I teach at Loyola in the Music Industry Studies program in New Orleans. I think the most important thing to know in copyright law is what rights you have under Section 106 of the Copyright Act. That's Title 17. And those are the right to make a copy, the right to make a derivative work, the right to sell and market that copy, the rights for public performance and public display, and another right that's only applicable to sound recordings, that's digital audio transmission of those sound recordings.
And those rights come to the creator in what form at what time?
Well, once you have the three elements of copyrightability together, your copyright starts. And those three elements are, you need the expression of an author, which is original in fixed form. So if you have originality, expression, and fixation, that's when your copyright starts right then. You don't have to file registration, but you should.
Expression meaning?
Instead of having, you don't have a copyright for an idea, you have a copyright for the way you express that idea. I could have an idea about, I love you, right? So how do I express that? What words do I use in my song? How do I paint a picture that expresses that idea? That's one fallacy in copyright, that people think, oh, he stole my idea, therefore he's violated copyright. No, it's focused on the expression of the idea. Well, Section 106 grants you exclusive rights, and Section 107 on in the Copyright Act takes away and makes exceptions to those rights. One of the important ones is Section 107, which is the fair use. There's another important one, Section 110, which is the Teach Act and has to do with using copyrighted materials in educational settings. The compulsory license under Section 115 is another exception. That means essentially that once a composition has been recorded on a record for sale in the United States, anyone can cover that composition if they do two things. First of all, they can't change the character of the song. They can't change the lyrics. They can adapt and make an arrangement of the melody to suit their singing style, but they can't change the lyrics, and they have to pay the publisher for that right. Every few years, the Copyright Royalty Board adjusts what's called the statutory rate. It's also called the mechanical rate or the compulsory license rate. Right now, in 2009, that rate is 9.1 cents per copy. So if you've made 1,000 copies of that composition, meaning you've pressed your version of that composition, your performance of it on 1,000 records, you pay 1,000 times 9.1 cents to the publisher. Fair use is a difficult subject to formulate easily. There's four things that judges look for in fair use. The first thing is, what is the use that you're making of the work? The second one is, what's the nature of the original work? The third one is, how much are you taking from the original work? And the fourth one is, what is the effect of your use of the work on the market for the original? Those are the four fair use factors. Of course, it gets much more complex than that.
Maybe you could talk about that for a second. The nature of the work?
When we talk about the nature of the work, what they look at are two things mostly. Is it fiction or nonfiction, and has the original work, been published or unpublished? So facts themselves are not copyrightable. But so fiction has more protection, and it's less of a chance of claiming fair use when you're taking fiction. The other example is whether it's published or unpublished. If a work has not been published by the author, meaning copies are not available for sale or distribution to the public, it's harder to make a claim for fair use. These things come up, I think, most notably in a case that involved the unpublished letters of a famous author. Whether or not taking those letters and quoting them in a book was fair use or not.
Are they?
It was very, very limited fair use. Essentially what the author could do is cite the letters but not the whole things, and just sort of take the essence of the letters. It doesn't. When you're talking about sampling musical compositions and using that, that's the whole gray album, the mashup between the white album and the black album. It doesn't really work that well. People think that they can do it, but fair use isn't what you think it is. Fair use, in every situation, there are no hard and fast rules. In every situation, you have to look at those fair use factors and figure out if you fall into that category. Fair use is not a right. Fair use is an excuse once you have been sued. One of the first factors is, what is the use you're making of the original work? If you're commenting on it or using it for some news or criticism or in an educational setting, it is more likely that your use would fall under the protection of fair use of that copyrighted work. But still, you have to look at the other three factors. What's the nature of the original? How much are you taking? And will it have an effect on the market for the original work? Copyright infringement is the way you protect your exclusive rights under Section 106. If someone has made a copy or used your work without your permission or without the protection of Section 107 or 115 or the exceptions that we discussed before, that is an infringement. So you have to prove in court the infringement took place. And once you do, there's several remedies and several paths to follow. First of all, you have to prove the infringement. So you have to prove that, first of all, you own a valid copyright, that the original work that you're claiming ownership in is an original expression of the author in fixed form. You have to prove that up. Secondly, you have to prove that there was some copying or something was taken. Then you have to prove that the defendant had access to your work. So once you prove these elements, you can move forward and ask for remedies. There's several remedies that you can ask for. You can ask for physical remedies, meaning you could request that the defendant's copies of the work are destroyed. You could also ask for statutory damages or actual damages. Actual damages pay you compensation for what you have lost as the copyright owner from someone else's use. If you've lost $1 and you can prove that in court, you can get $1 back. If, however, you have filed your copyright registration before the infringement or within 3 months of the first release of your work, because that would make it retroactive, you can have the possibility of asking for statutory damages. Statutory damages run in a range usually between $750,000 and $30,000. So if your actual damages are only $1 and you followed the proper procedure under copyright registration, instead of being stuck with asking for $1 in damages, you can request the $750,000 to $30,000. But wait, that's not all. If that infringement was willful and you can prove it, that top amount of statutory damages can go up to $150,000. On the other hand, if the infringement was innocent and the defendant can prove that, that statutory rate can drop down to $200 in damages. That's the main place where it comes in play, but there's several other reasons to register your copyright. First and foremost, it is a public record of your ownership, or at least your claim to ownership. If you're going to sue somebody, you need to have that registration before you can even file suit. In fact, in a copyright infringement lawsuit, you've got to have your registration stapled to the back of it as Exhibit 1, that you have filed your registration. Also, it can protect for infringing copies being imported into the United States. And you need that for other certain compulsory royalties too. If you don't register within 3 months of first publication and you don't register before an infringement, you don't have the option to ask for statutory damages. So that's the encouragement, to file your registration within as soon as you can, within 3 months of your publication, and definitely you want to file it before any infringement.
So you can still sue for infringement, but you just cannot collect statutory damages. So you're left with actual damages.
Right. If the infringement took place before you filed and you didn't file within 3 months of registration, you're stuck with asking for actual damages. You don't have the option to ask for statutory damages.
What happens if you have not registered your copyright and you wrote the song and released it 10 years ago?
You can file for copyright registration anytime you want.
Isn't there a loss of the presumption that you wrote it after 5 years?
If it gets to, let me think about this for a second. If you file, wait, I don't want to say anything because I don't know exactly. If you file within 5 years, I think you have the prima facie assumption, but I don't know for absolutely sure that it's 5 years, so I don't want to say anything.
Okay, we can get to that some other time.
Yeah.
Okay, well, let's go into the Teach Act. If I'm a choral conductor.
Excuse me, there was one more thing I wanted to say about infringement and proving up infringement, which is about access and substantial similarity too. I didn't get to that. When you prove up infringement, the important things to look at are access and substantial similarity. Not only does the defendant have to have access to your original work, but you're also going to have to prove that the defendant's work is substantially similar to yours. Just because he had access to it and wrote another song that was similar in nature doesn't necessarily mean that it's an infringement. You have to prove substantial similarity.
That's a case-by-case basis?
In every case, you need to prove to the judge and jury everything that we talked about before, that you own the valid copyright, that there was some sort of use or copying without your permission or without the protection of Section 107 or other exceptions to the Copyright Act, and also that the defendant had access and substantial similarity in the works. Sometimes you would use a musicologist or an English professor to compare two works of fiction to see how substantially similar they are. Oh, there's a whole list of works that are copyrightable in the law, but the important thing to learn is it's not an exclusive list. Congress made it kind of vague, and they listed some things that are clearly copyrightable, but left the option for other things that we haven't even considered to be copyrightable to be added to that list. But right off the bat, musical works and compositions, sound recordings, books, plays, other works of the performing arts like ballets, pantomimes, choreography, painting, posters, photography, sculpture, architecture, a whole bunch of things. Copyright protection gets confused with patent protection. The patent protection applies to a process or a method or a procedure or a formula. Copyright really talks about the expression of an author's original work in fixed form. For example, E equals mc squared. That is not copyrightable. But if Einstein wrote a book explaining his formula, yes, he could get the copyright on that. There's other things that aren't copyrightable, things like calendars or works in the public domain. They're just excluded from that for failure to be original. Titles and short phrases are not copyrightable either. By the way, the last time I looked in the Copyright Office, there were over 3,000 songs with the title I Love You. The Copyright Royalty Board sets the rates. It's usually every 2 years that they meet and decide the rates. They've stayed steady for the last, I guess, about 6 years or so. Under the old act, the 09 Act, it was 2 cents a record went to the publisher. Now, 100 years later, it's 9.1 cents to the publisher. So until 1978, when the new act, the 1976 Act, came into effect, it stayed at 2 cents a record. So the compulsory rate moves up when they decide it's appropriate. Of course, there's public hearings before that happens. When you're looking at the length of copyright protection, there's a few things to keep in mind. First of all, the Constitution grants you exclusive rights to your work under Section 106. But the Constitution also says that these exclusive rights are granted for a limited time. So what's the limit on the time? That's the real question. There's 2 questions to ask. First of all, was it a work for hire, or did the author or authors just write it on their own without being employed or specially commissioned to create this work? Well, if an author or 2 or more authors wrote it together, that is, the original expression of the 2 authors in fixed form, and of course they had knowledge and agreement that they would combine their efforts together, then the copyright lasts for the life of the last surviving author plus 70 years. In a situation for a work for hire, where someone is, for example, employed to create copyrightable work, then you look at a different method of calculation. It's either 95 years from the date of publication of that work, or 120 years from the date of creation of that work, whichever one is shorter. Once copyright protection ends, and by the way, it ends as of December 31st at midnight at the end of the year, when copyright protection ends, that work goes into public domain, which means there are no Section 106 rights anymore. Those exclusive rights have expired in that work. So that's why we don't have to chase down the great-great-great-great-grandchildren of Shakespeare to put on a play, because those rights go into the public domain for anybody to use any way they choose.
Do you want to talk about the right of termination for a second?
It's an incredible pain in the butt. And no.
Come on, Mark.
Except to say, it's an incredible pain in the butt. But especially under the old stuff. Under the new stuff, I can talk about that. For works created after January 1st, 1978, if the copyright has been sold or transferred to someone else, that person has the right to reverse that transfer in 35 years. There's lots of reasons for that, but partially because of the old law, you filed for copyright protection for 28 years plus a renewal of 28 years. So under the old law, if you were stuck in a bad deal, maybe you could get out of it before the renewal. Under the new law, we don't calculate by renewal terms. There is no renewal under the new law. It goes by life plus 70. So if you're in a bad deal, you're stuck. And that's where the 35-year termination right comes into play. There's a complicated procedure on when you can send notice to the person to whom you transferred your rights, and what window of opportunity you have to file that notice, and when they have to respond and revert the transfer back to you. There's two situations where a work can be a work for hire. The first situation is if it is created as a result of an employer-employee relationship. It is your job to create something that is copyrightable. Your employer owns the copyright. The second way is if you're specially ordered or commissioned in writing before the creation of the work, that can be a work for hire also. But there's a list of things that fall into that category of work for hire. Yeah, because they're specially ordered or commissioned ahead of time. And if you notice in most contracts that create a work for hire situation, most commissions to create a work for hire situation, the language says this is to be considered a work for hire, but if for some reason it's not considered a work for hire, we will then consider it as a transfer, an assignment of all of your rights under copyright to the employer. So it's suspenders and a belt. Most sound recording contracts, most recording contracts are works for hire, where the record label has specially ordered or commissioned the recording artist to come up with a master tape. Now, whether or not that will hold up, we'll have to see. The Teach Act came into existence to answer some unanswered questions about Section 107 fair use, especially in the situation of face-to-face education and online education. In face-to-face education, a lot of teachers were wondering what could they do and couldn't do in the classroom. Could they make 100 copies of an article from a magazine? Could they perform things in the classroom? Many more questions were raised when we started moving into online or distance learning. So the Teach Act applies there. Essentially, and this is an oversimplification, anything you do in face-to-face teaching situations you can do online if, and there's a whole bunch of ifs. There has to be a limitation on the amount that you use. You have to consider the time that it's available for the students. You have to consider the time of your classes. You have to limit access to students for that semester, usually through a password situation. You have to take extra steps to try to prevent unauthorized copying. And first of all, you have to start with a validly purchased copy to begin with. There's a lot more complex things in the Teach Act. Whenever you're looking at something in the Teach Act, just like fair use, you have to ask a lot of questions because fair use still applies under the Teach Act. So even though the Teach Act says you can do certain things in the classroom, that's you still have to look to your Section 107. You know, how much are you taking? What's the effect on the market for the original? What's the nature of the original work? And we're assuming that it's a nonprofit educational use that you're putting it to. Well, you can buy my book, The Teacher's Guide to Copyright, and that explains in a little bit more detail what you can and can't do under fair use and under the Teach Act. And in the book are checklists. And again, we're looking at the fair use issues and we're looking at the Teach Act issues, not only in face-to-face teaching, but also in distance learning or online learning. You can go through these checklists and ultimately it's up to you to decide. You have to go through the checklists and there's certain factors that favor fair use and certain factors that work against your claim of fair use.
Well, can we be specific for a second? I asked you earlier about the idea of buying a piece of music and reproducing it for your choir, which often happens with music teachers who have limited budgets. How does the Teach Act affect that?
One of the problems you're going to run into with making multiple copies of sheet music is the fourth fair use factor. You're having quite an effect on the market for the original work. And certain works that are created specifically for teaching, you can't make copies at all. So with every situation, you have to look at each one of the fair use factors and the Teach Act too.
So I couldn't necessarily play an entire Beethoven symphony from a Deutsche Grammophon recording in the classroom, but I could play a part of a movement?
For music schools, this question comes up: how much of a symphony or opera can you play in the classroom? One of the things that the Teach Act says is you have to look at the time of the class. Do you have a 45-minute class? Well, you're not going to play an entire Wagner opera during your 45-minute class. You might get half of an aria. So that's one of the factors to look at. Also, you have to think, is it available to the students? Can they check it out of the library and listen to it on their own? What is the point you're trying to make? What are you teaching that you need to play that aria or that symphony? And it could be different points and different issues for different teachers and different classes. All of that has to come into effect. There's a famous case for the sheet music classics to moderns, I think, where a publishing company claimed and sustained its copyright on its arrangement of a public domain work. So that arrangement met the requirements of an original expression in fixed form.
Because it added new material.
I think in the classics to modern situation, it added fingering for piano students. And that was an addition of new material to a public domain work.
Right.
I get this question asked a lot by teachers, and it seems to me that teachers have three different approaches to fair use. The first approach is a pirate. I'll take what I want, I'll use what I want, I don't care, I'm a teacher, I'm exempt. The second approach is, oh no, I'm not going to make a copy of anything ever. If I use a work, I'm going to sit it on the table and people can't touch it. They have to read it in the classroom while I'm there and they can't even breathe hard on it. And the third approach is like Sergeant Schultz. I know nothing, and they try to get around it that way. What the Teach Act and Fair Use is trying to do is give a little bit better set of guidelines for practical use of material. If we go back to the reason for copyright, it's always a balancing act. We have exclusive rights granted to authors because we want them to create copyrightable works. The monopoly is our reward to them, that they have exclusivity over making copies and derivatives and selling those copies, etc. But we also favor the free transmission of ideas. And that's why those exclusive rights are limited in time, also limited in use for fair use. So we always have a balancing act between the monopoly rights to encourage authors and the movement towards free transmission of ideas. My contract with the university doesn't mention anything about the material that I have created for my class. So I own the material that I've created for my class. Now then again, I can't just turn around and publish all my notes and examples and MP3s and photographs and other things that I use in my class, because I am using them under the TEACH Act, either in face-to-face teaching or in distance learning where it's password protected and it's turned off at the end of the semester and it's for limited times. So I'm trying to take advantage of fair use and the TEACH Act for my students to give them a rich environment for learning all these things about copyright. For salaried faculty, you really have to look at the employment agreement. Was a work-for-hire situation created in the employment agreement? This issue is starting to rear its head in copyright now, with professors selling their courses or marketing them different ways. But as far as patents go, this issue was addressed several years ago, and research scientists who come up with patents usually have some sort of ownership sharing agreement with the universities. And you have to look to the employment contracts to answer those questions. Once you have three elements together, the fixation of the original expression, you as the author own the copyright, which means you have all the Section 106 rights. The right to make a copy, the right to make derivatives, distribute and sell copies, public performance, public display, and number 6 for sound recordings only, digital audio transmission. Songwriters own their publishing from the moment the copyright is created. But songwriters aren't always good salesmen for their songs. That's where they need the publisher to come in. The usual agreement between a songwriter and a publisher is that the songwriter transfers his copyright to the publisher in exchange for 50% of the money earned by that composition going back to the author. That's the standard publishing deal. Obviously, you don't have to transfer 100% of the copyright, and it doesn't have to be for 50% of the money, but let's just stay with the standard deal. So once that copyright has been assigned to the publisher now owns the Section 106 rights. The publisher controls making copies. The publisher controls making derivatives. The publisher controls public performance and public display and distribution of the work, and has agreed to share that money with the author. Once an author has created something, he owns all the rights, therefore he's wearing two hats. He's wearing the songwriter hat and he's wearing the publisher hat. If he wants to do a deal with a publisher and transfer all or portion of that copyright, then that second person is the publisher and he remains the songwriter. Oh, you got enough tape for this one? We use electrons. The copyright law has always been a step behind technology. Copyright wasn't around when Gutenberg came up with the printing press. Some sort of control had to be implemented after that. When you were in Rome and you wrote a book, you'd get 20 scribes to make a copy of it, so you controlled the copying. The same way before Gutenberg made it easy to make copies. So copyright law, in my opinion, is always a step behind. When we had the first copyright law under the US Constitution, it only protected literary works, maps, and charts. That's it. Well, what happens in the middle of the 1800s? We get photography. Well, that gets added, along with several other things, too. What happened to Edison when he came up with the first movie? He filed copyright registration for Fred Ott's Sneeze, and the Copyright Office kicked it out. They didn't know what it was. What's a movie? We've never seen one of these before. So he had to refile by taking the individual frames of the movie, snipping them apart, and pasting them to a piece of cardboard, and then submitting it again. Then the Copyright Office said, oh, it's a bunch of photographs. We know about copyright on photographs. Oh, okay, that's fine. And so later, motion pictures became copyrightable. Sound recordings were not copyrightable in the United States until February 15th, 72, I think. So the law is always a step behind technology. And nowadays we have file sharing and the ease of making a copy by just clicking the button on your mouse. Again, the Copyright Office is a step behind. They'll catch up, but who knows what the future holds. There's a whole bunch of solutions that have been tried for some sort of protection for the copyright owner's rights in the real world. People have tried digital rights management, people have tried password protection, or some sort of automatic dying off of a software program after a certain number of days. We're still coping with this. Some people have thrown their hands up and say, it's free. The internet is a copy machine. I know that if I put anything up on the internet, I have lost 100% of control over it. I'll just accept that and try to earn money some other way. Right now, in 2009, the record companies that are left are still trying to figure this out. So the entire record industry is under a major evolution now. Somebody will figure it out. They're working on it, but they haven't quite figured it all out yet. But someday they will. You're asking a philosophical and ethical question, but I understand. I mentioned before about Section 106, number 6, which is the exclusive right for digital audio transmission of a sound recording only. You might notice if you buy a CD, if anybody buys CDs anymore, the P in the circle symbol. That means that the sound recording is protected by copyright. So there's only 3 ways for a record label to make money: through the sale of its sound recording, through leasing or the tape, meaning leasing it to a movie studio to use that sound recording in a movie or a TV show or an advertisement, or third is the digital audio transmission of that work. So far right now, that's only applicable to satellite radio and webcasters. But in the future, just as television is moving from analog transmission to a mandatory switchover to digital transmission, the same thing is going to happen in the near future to radio stations. So when that comes into effect, who knows when it's going to be, all radio station transmissions will by definition be digital audio transmissions, and the owners of the sound recordings that are played over those radio stations will get money for that, just like they do now through webcasting and through satellite radio airplay. Copyright is in the Constitution. I know, I went to Washington to the archives and I read it right there. Um, I think it's very important for two reasons. First of all, the founding fathers, and especially James Madison, who's the patron saint of copyright, understood something that a lot of people didn't understand in 1789 when the Constitution came out. Madison said, just as it's proper to say a man has a right in his property, it's equally correct to say he has a property in his rights. And that's what copyright is all about. Because I have copyright in my work, I have these rights. And just like regular property that I would own, I can buy and sell and lease these rights as if it were real property, even though it's intangible property. That's a subtle yet fundamental change in thinking, that we're able to buy and sell intangibles and earn our money from that. The second reason I think that the founding fathers thought copyright was important is because they were all authors or booksellers themselves, and they understood the power of the written word. For example, Thomas Paine, Common Sense. My God, it was a hit by any definition of the term. And Thomas Jefferson, James Madison, Benjamin Franklin, they were all authors. Ben Franklin had his own printing press. Henry Knox was a bookseller. He was the general of the army. That's why we have Fort Knox named after him. So all of these people understood the importance of the written word back then. And while the Constitution was being debated by all the states, you had the Federalist Papers with John Jay and James Madison and Alexander Hamilton, who's on your $10 bill, arguing in favor of copyright and all these other features of the new Constitution. So they were well-read men, they were literate, and they understood the value of copyright. Well, unlike real property where you may own a piece of land forever, you're not going to own the copyright forever because just as we're granting a monopoly, it's for limited times. So always, and whenever you're thinking about copyright, you have to go back and forth and understand the balancing work. Monopoly, free expression of ideas. And that has to be applied to every copyright situation. In my opinion, Western civilization is built on the free transmission of ideas. And that's what gives us strength and vibrancy and the ability to evolve and change and adapt because we can exchange ideas. Now, on the other hand, we want to encourage people to come up with these copyrightable works so we can discuss them and comment and criticize them and use them for news, and eventually they will work their way into the public domain when it's free for everybody else to use. But I think that perpetual copyright is a bad idea. We need something to move culture forward. And on the other hand, people that just infringe willy-nilly are impeding the movement of culture because the people that are doing the hard work aren't getting compensated for it. I think Creative Commons is a good idea as far as a framework to follow, to have a standardized licensing, but Creative Commons is not a substitute for copyright. A lot of people think it is, and Professor Lessig says it's not. And secondly, there's a few problems with Creative Commons. First of all, once you've released your work under a Creative Commons license, you cannot take it back. It's out there forever. Second thing, if you're relying on a Creative Commons license that someone else is granting to you, you have to think about, did that person granting it to you have all those rights that they purport to have? So every link in the chain has to be correct too. And you have no control over the prior links in the chain. One of the things that I think is very important for creative people, people who write songs, people who perform music, people who take photographs, people who are painters or choreographers or novelists, is to understand their Section 106 rights, that they control these rights. And if they assign them in some sort of contract, that they have lost control of those rights. I've seen it for years and years where people come in and sign a bad contract and then try to get out of it once they've seen the light. The best thing is to know what you're doing before you sign the contract. And that's very difficult, and that's what we're doing here at Loyola, trying to teach kids how to survive in the music business and to learn their rights under copyright, to learn about publishing, to learn about sound recordings, to learn about record labels, to learn about all these things and not just sign any piece of paper that's put in front of you. Record labels have very good lawyers that know all about copyright. They're fully aware of all the nuances and nooks and crannies of copyright law. In my opinion, the point of view of the record label is monetary. They are risking an awful lot of money by signing a new act and releasing a record on them. Most records don't even earn back enough money to put the artist in a recouped position. Being a record label is the riskiest business on earth. If you go to the racetrack, one of the horses has to win the race. So one of them has to win. If you're in the record business and you put out 100 records, nobody has to buy any one of those records. It's total risk. And so from the point of view of a record label, they want to make sure that if that record becomes a hit, that they earn enough money from that record to pay for the costs of its creation, to pay for all the other ones that lost, and to keep making records next year. Who knows what the hit records of next year are going to be? No one knows. But people are recording them right now. So, as I said before, the riskiest business in the world. I think the best advice for a musician is to be very aware of all their rights and try to do it on their own. Do you really need a big record label? Yes or no? I don't know. You have to answer the question for yourself. But if you control all your rights, you're taking 100% of the risk. It may be fantastic, it may be a flop, but at least you're in total control in that situation.